Tracy Krause, who is one of our most valued support people, legal assistant, paralegal, and Tracy is going to explain a little bit about the technicalities of our presentation. Tracy?
Alrighty, my name is Tracy Krause, and as we mentioned earlier, I am a paralegal with the Estate and Elder Law Planning firm, a firm that focuses on estate planning and elder law in Arkansas. And I don't think Susie mentioned, but we do have 4 offices in Arkansas with 5 attorneys. And during this presentation, you'll have the opportunity to ask questions. And if you look down at the bottom of your screen, you'll see that there's a little chat button. And if you'll click on that, a little box will open up, and that's where you can ask questions. And if you will send those questions, you can send them to the whole group if you want, but you can send it just to me, and I'll monitor these questions throughout the presentation. And when we get to the end, we will answer all of your questions. Another thing is we'll be asking some thought-provoking questions as we move along through the various topics that we're going to cover today. And we'll stop and we'll ask those questions. And if you'd like to respond in the chat box, feel free to do so. And we will go from there. Anita, are you ready to move on?
I am, Tracy. Thank you. And also, just a quick note. I thought we were going to have everybody muted, and that's really the best way to proceed if you're not speaking. Keep yourself on mute to avoid interference. And our audience, if you would please rely on the chat, that would help the presentation go more smoothly. Thank you. So our first question to think about and we wonder whether you have had the experience of having someone die and seeing how things can go so very wrong at a stressful time when there's a lot of emotion going. There can also be a lot of difficulty if the person has not planned the way we would like to persuade you to do. So Mitch is going to talk to us about this.
Okay, and we as attorneys, paralegals, we see all of these plans at various different times. We have the natural plan, the will, the beneficiary plan, the revocable living trust, and an asset protection trust. And these are all of them except the natural plan can work and work out much better than the natural plan. So we'll talk a little bit about the natural plan first, and I believe we have a slide that will give us an illustration. Okay, but also before we get to that slide, I want to tell you that there's going to be a lot of information here. You can take notes if you want to. I would suggest that you listen. Many times, it's just the way my brain works. If I listen intently, I will actually absorb more rather than busily trying to take notes, because there's going to be a lot of information here. As an old instructor of mine said, this is like drinking from a fire hose, isn't it? So today we're going to give you the big view, okay, from the top, and you should get some information from that, and it'll inform you about, at least you need to go down this road, and then you're going to know some questions to ask, how does this apply to me? So we'll begin, and I think there's our natural approach. And do we have the answer to that polling question, Tracy? Anybody respond to that?
No, nobody responded. But again, when we ask these questions, please feel free to jot your answers down in that chat box and send them to me so we can let everybody know what you've experienced.
Well, we all live in Arkansas, probably, and likely we have all seen what happens after a tornado has gone through a community. And so that's pretty much the natural approach to estate planning. Everything is scattered about hither and yon. As attorneys or paralegals, we have to dig, find things, look through bank statements, old files, etc. It can get very, very expensive. It exceeds the expense of planning. Planning is very valuable, but this is what we find, and we put our loved ones, our husbands, wives, children in this position. I know, especially today, I see a lot of elderly women, maybe in their 70s or 80s, their husbands took care of everything. They never did anything. They couldn't get their husband to do everything, and they leave their wives in this situation. We do put it back together for them and organize it and get it into a trust or something, and or an asset protection trust or a revocable trust, so that it's organized, easy to manage, and easy to find. But none of us want to be here, okay? This is bad for everybody except lawyers. we generate a lot of income from cleaning up the mess. And we do a lot of it, a whole lot of it, more than we would want. We would really rather plan. So I think we have another slide now. And a question.
So, true or false? Does a will help you avoid probate court? And if you would, just jot your answers down in the chat box and send it to me so I can see your thoughts on this.
It would be great to see these answers, and that kind of informs us about how we need to proceed in the talk. Okay, so Anita, you want to talk about the will approach?
I will be happy to. So this is a really common thought in most people's mind. All you need is a will, and you've done your duty. But the prior question suggests that actually the will is not the best way to go in most circumstances, because it will take your family straight to court. And it may sound funny coming from lawyers, but we really don't want our clients to be in court. It adds to the expense, it adds to the public exposure, because there are people out there who troll through court records, and if there's any personal information they can grab onto to either exploit or to assume and take over, they will. So it's really important to avoid going to probate, paying auctioneers, paying lawyers, sort of scrambling to get all the property collected in court under the supervision of a judge. You lose control of a lot of your affairs. Now, that said, a will is a very important document, but it shouldn't really be the only document. So let's see Tracy, do we have any answers to that?
We do have a couple. One person said, I don't know. Another person said, that's false. My husband recently passed away and I had to go to probate, and he did have a will.
There you go. Well, I hope your experience wasn't too difficult. We make a lot of, we give a lot of thought to how to avoid that situation. So here's another question. This is something we see a lot. The people often take this approach, that they're concerned about being able to pay their bills if they are incapacitated for some reason, and they want their child to come in on the bank account. Have you heard of that? Do you think it's a good idea? And we will, of course, tell you what we think, but we'd love to hear what you know so far. So while you're thinking about that, the idea to put property in a joint bank account or transferring those bank accounts by designating a beneficiary, or your retirement or insurance accounts, the same idea, we call that a beneficiary plan. And it's also possible to convey real property, real estate, your home, by a beneficiary deed. These are really efficient approaches to estate planning. They're definitely better than the natural approach. They have some improvements over a will and some disadvantages. And, you know, when I get into this detail, I always want to remind people, just like my colleague Mitch said, please don't try to absorb all these details. Estate planning is kind of weighing all these options, and depending on the person that we're looking at, their family situation, we will guide you all through these intricacies. So there are advantages to beneficiary plans, but there are disadvantages. They work well with a bunch of other options that will protect your children, that will designate a person whom you want to care for your children if you have them and you're not there to do it. There are ways to protect your heirs from medical or financial catastrophe, bad marriages and divorces, and unfortunately, none of that protection will happen in a beneficiary plan. And worse than that, not to say that this would happen in your case, but we had one very, very sad case where the elderly woman had 4 or 5 children. She put one of those children on her bank account, and that child stole everything. And the result was a protracted litigation in court, incredible bitterness, and very difficult to recover any value from what she had basically wasted. So that's an exposure in a joint bank account that we really don't want to see people do. So Tracy, how about any thoughts on the joint bank account?
Yes, we had some. Some folks thought that was a good idea.
Yeah, it's really not. There are alternatives, mostly with a power of attorney, which we'll get to later, but we really don't recommend that you do your estate planning that way.
I want to interject something, and this is just, this is my way of looking at those jointly held accounts or joint ownership of real estate accounts or whatever you may own. If your child has financial problems and marital problems, they've just become your problems as well. Or maybe they have a medical catastrophe that turns into a financial catastrophe. I have seen that occur, and I have seen mother lose $200,000 to medical collections because she had her daughter on a CD as a joint owner because she thought that was a good estate planning vehicle. It's very bad.
Now, again, that's absolutely the case, but there are aspects of this that work very well. So again, we will look at your whole situation and assess each element of the plan to make sure that it fits comfortably and doesn't result in that terrible problem. So here's another question. What do you think? It's very, very common to hear the word trust. Think about trust children and think that trusts are only for the very wealthy. Have you heard that? What do you think? And while you're thinking about that, and please do tell us, because we want to know. Mitch, tell us about the Revocable Living Trust, please. Whoa, we can't hear you anymore, Mitch.
Hey, okay. You know, and I have to, does anybody see the name Natalie Cash up there where I'm sitting?
I do.
Oh, yeah. Well, that's my wife. I'm on a laptop at home. Usually you can see I've got everything dark because it doesn't look good. But I don't, so my name's Mitch, not Natalie. But anyway, you know, we have different vehicles for different projects. I live on a farm, but I work in a law office. And so my farm's a good sized farm. But to get to work and back, I drive a Honda CRV. It gets 33 miles to the gallon. It's very inexpensive to operate. I only have to put tires on it once every 2 or 3 years. On my farm, I have a 1-ton truck with an extended cab, bale bed. I can pull cattle, backhoes, tractors, hay. I even have an 18-wheeler to move a bulldozer and haul other equipment with. I have the tool that I need for each job. And so estate planning is a lot the same. These things can be looked at as tools for a lot of people. The Revocable Living Trust is the right job. I'm 58 years old. My oldest child is younger than 24, and my youngest child is 20. And so it's not that I have a bank vault full of money. If I was a trust baby, and I've seen a few, I probably would be doing something other than sitting at this video. I'm not, but I do have enough assets that I need to have a trust. I wouldn't turn my children loose with the assets that my wife and I have accumulated at this point in our life, but it's not real hard to get to. It's very easy for my wife and I to manage those assets inside this trust. Just like you see here, I mean, we have some open drawers. We can get things in and out very easily. We don't have to ask anybody. We just go get it. We can shut the doors fairly easily. And if we want to, and we can actually make it a little harder to get in there and get some of those things, but that's really not the point. We're not at that point in our life yet. So the big thing that this trust does for us is this. It protects our children from themselves until they reach a certain age, and we're able to change that age as we watch them grow. And it also does one other thing. It would protect them from a bad marriage. Or I have a couple of children that are married. Things seem to be going very well. I don't think that's going to be an issue, but nevertheless, it could be. It could be 15 years down the road. So I'm always going to have some protection in there for bad marriages, or if they suffer financial catastrophe, I want to protect them from that as well. If they become disabled, if one of my children were to be involved in an accident, they were unable to work, and the Social Security Administration had found they were disabled, and they received disability insurance benefits or supplemental security income along with Medicaid, other needs-based benefits like housing or food assistance, my trust is going to say for that particular child, we're going to put their money in a special trust called a special needs trust, because this first person is disabled, and we're going to keep them qualified to get all of these needs-based benefits that I talked about. Plus there's going to be a pool of money over here to buy, let's say they needed 3 sessions of physical therapy a week, but Medicaid would only pay for 1. Okay, we're going to reach into this supplemental needs trust and we're going to get the money out of there we need to buy that extra couple of physical therapy sessions. Or if it had always been their dream to go to Disneyland and they never got to go, this trust will pay for that child and a companion to make that trip to Disneyland, something that would be wonderful for that child. And so trusts do all of these things, and we do more than that. But the Revocable Living Trust is a really powerful tool, and it has its application in the right circumstance.
Yeah, and the other thing about a trust, it's wonderful how it works, because it kind of bridges the life of the person who created the trust and the estate planning idea that when that person passes, the instructions to what to do with that property are contained also in the trust. So it's a very flexible, very valuable instrument that does not require huge sums of money to justify it.
Well, I'll say one other thing about the Revocable Living Trust. A typical probate case is going to be, for a lot of people I see, the attorney's fees are probably going to be $10,000 to $12,000. Most trust-based plans we do are $4,000 to $5,000, and so about a quarter of the cost to do the trust, and that includes much more than just a trust. The trust is one thing in a trust-based plan, but there are many things included in that and a lot of planning.
That's really why it's sometimes difficult for people to think about estate planning in terms of the expense. I don't want to spend the money now, worry about it later. Unfortunately, that short-term view does not account for what Mitch has just described. And the initial outlay is so worthwhile. I know you'd expect us to say that, but it is the fact. So here's another question, but I don't want to miss one. Tracy, did you? Yeah.
Yes, we received several responses. Most people did think that having a trust was only for the wealthy.
There you go. All
no,
right.
It is not.
It is not. All right, so now we're at another question. This is a very common concern. Worried about losing your house and savings. You've heard how expensive the medical care can be if you have a chronic condition or you need nursing home care. The expense is absolutely staggering. It can get as high as $70,000 a year. Where is that money going to come from? Is it going to mean that you have to sacrifice your house? So if you've heard about that, do please let Tracy know in the chat if that's a concern of yours.
While people are answering this question, compare, I told you what typically we say is the cost of probate for most estates is probably less than $12,000. And that's the cost of getting it done. It can be more than that, quite a bit more, but that's pretty normal for our offices based on the value of the assets our clients have, which is usually around $500,000. And you compare that to the cost of long-term care at $60,000 or $70,000. And we've all heard, oh, avoid probate at all costs. Yes, we want to do that. And we're always going to do that for our clients. But what the biggest concern is for most of our clients I'm 58, or at least my age and up, is what happens if I have a stroke or I have a heart attack or if I get Alzheimer's? I'm seeing people my age that are diagnosed with dementia or Alzheimer's. That is becoming, it's kind of a silent epidemic that's occurring in our country, but it is occurring, and it's occurring at a much more rapid rate than it did, say a year ago even.
Yeah, and with the epidemic we're in now, it's hard to calculate, but there's an awful lot of concern, and rightfully so. So we do have one very specialized kind of trust to offer to guard against that particular situation. And this document, you can see by our illustration, it does not resemble the other one with the open drawers. That is a bank vault door that slams shut on this trust for the person who creates it. And then there are various avenues, various other little side doors that are available to start using the money. But the main idea here is that we do these trusts with an eye toward the Medicaid government assistance program. And perhaps you've heard of how that program will step in and take over those staggering costs, but they basically require on paper that the person getting that assistance is pretty much broke, can only own about $2,000. So we take the money that you have and we put it behind this bank vault door. And if within 5 years you can stay out of the healthcare situation, once you pass the 5-year mark, Medicaid will step in, take over all the costs of the residents and the medical care, and your the money that you've worked so hard to gather is safe for your children. And it does a whole bunch of other things too. You've heard us talk about protecting the children from bad marriages, from bankruptcy, from all kinds of creditors. They've just bounced right off this trust. You get to decide where you want your property distributed when you pass. It can protect your children by naming a guardian or a trustee. It has that little sub-trust in it that Mitch mentioned about the disabled child to protect that person's benefit. No probate involved with this one. And again, the key thing about this is that within 5 years, you are really, your whole estate is protected. Now, it's true that this kind of trust is irrevocable, although we lawyers know certain avenues to be able to change key provisions, but the basic idea is that you can't change them. They're also internally quite complex. We give a lot of advice along with this for tax preparers and accountants and the like, to kind of guide them in how to deal with the tax situation. There's a good deal of complexity associated with these trusts, but they are tremendously valuable in the right circumstance.
Yeah, and I would like to say, Anita, don't be afraid to ask about an asset protection trust. I mean, if you're talking to us, we will tell you if this is right for you, and that this is not for everybody. But for some people, this is an incredibly strong tool, and it works beautifully. It's not for everybody, but under the right circumstances, it is fantastic. And I probably do several asset protection trusts every month, and for different folks. Some people come in and they would like an asset protection trust, but it's not going to be good for them. And so we decline that work whenever we can see it's not going to fit. Well, that's our job, is to do the best we can for you. And sometimes we have to just say, no, we can't do that, because I see down the road, this is going to be a very bad fit for you.
So
We did receive several responses that some of the participants are concerned about long-term care.
Yeah,
Okay.
It's a real worry. It's true.
And we do that. We see crisis plans all the time, people that have done nothing. And, you know, even in a crisis plan, if a husband or a wife is in a long-term care facility and they at least have some power of attorney documents done that are reasonably good, you know, we're able to protect a lot of assets. And even if one of the spouses has passed and the surviving spouse is going into a long-term care facility, we can still protect a lot of assets, and at least half to sometimes all of them, just depending on the fact situation we have. And so don't worry about these things. Find out what your alternatives are and what's going to work for your family, and begin to implement a plan and remove that anxiety from your plate. You got other things to do besides worry about this, because there are answers.
All right, so we want to make a little shift now between what we've been talking about, which has been principally focused on how to protect your property for your children. And this is kind of a facetious way to say it. I don't personally believe that dying is easy. I'm kind of not wanting that. But the idea here is it's going to happen no matter what. There's nothing I can do about it. But let's talk about the kinds of problems that we can have while we're still here on the planet, and how we estate planning attorneys, which is kind of a misnomer in this situation, can help. So here's a situation we see an awful lot of. The kids are now grown up and going to college, and they're still your child. So how come you wouldn't be able to call the doctor for the child, take care of everything that you need. Why would you need a power of attorney for that? We are talking about children who are, under the eyes of the law and no longer children when they reach 18. Have you thought about that? Do you really think that if your child is in college, it's really premature? You don't have to worry about estate planning and powers of attorney.
And if you have grandkids, be sure and ask you'll find out. You need to tell your kids, think about this.
Yeah, so Mitch, I think you have a story that goes right into this next one about the healthcare power of attorney.
I do. And so all the ladies said that I had to be quiet unless called upon because I talk way too much. But anyway, so my wife, being a loving mother, and it was our last child, graduated high school, and he graduated at the age of 17. And then shortly after his graduation, he went to see his last trip to the pediatrician because he would be 18 and very shortly. And so, as always, my son, he drove, so he drove himself to the doctor, and my wife would always call and they would talk to her. And so she called the next day and she said, well, tell me about Ian's visit. What's going on? And the young lady said, well, I can't. And she said, what? You can't? I'm his mother. And she said, he's 18. And she said, so what? But he's 18. He's the age of majority. HIPAA kicks in. Legally, the healthcare profession can give you no information. So my wife said, well, she didn't say, ask what to do. She knew what to do. And she said, we need to get some healthcare power of attorneys. And so we did for all three of our children. We also have general durable power of attorneys for our children. Not that, and I don't pry into their lives or do anything unnecessary, but unfortunately, we think of our children, maybe our grandchildren, maybe grandparents, not so much, but we think our children are bulletproof. It's never going to happen to them. And, yeah, things do happen to our children. And I've known parents that have been in that situation and their child has been in college somewhere and they called the hospital. They couldn't find out anything. They even went there, drove 2 days, couldn't find out anything, had to get a guardianship in that state where that child was in the hospital before they could get more than just a little bit of information. And they couldn't make any decisions, et cetera. It was, the anxiety was, I can't imagine what it would have been like. So I have all those for my children and my mother, my aunt, my whole family. I actually keep healthcare power of attorneys and HIPAA documents on my cell phone for my entire family. And if something occurs somewhere, I can always email it to the healthcare provider and I can get information really pretty quick. And they're very happy to see it. They're really happy to have somebody to talk to.
Yes, and our documents too are not just your average 1 or 2 page forms that you might have seen if you do go to the hospital yourself. Our documents are very comprehensive. They're very specific and they delineate exactly the kinds of situations where they are important and can be used. So there's the healthcare decision making, and then the other question is the barriers that go up. I mean, sometimes it's even hard for me to get my own medical records. The healthcare professionals are trained to be very cautious about allowing access to this private information. So you need a separate document that says, let my agent see my medical information. And without that, it's just a lost cause. And we hate to see people in situations of great stress and anxiety have the additional layer of these legal obstacles placed in their way. It's really hard to watch. So we also have, so those, we just talked about basically 2 of the documents, the healthcare power of attorney and the HIPAA release. HIPAA is a federal statute that keeps medical information private. And we also have 2 other documents that we include in our package for when, at the end of life, when it becomes apparent that modern medical technology could keep a person alive for a very long time, but the quality of life is really poor. The prognosis is bad. There's just a constant deterioration. There's just one crisis, medical crisis after the next, bouncing back and forth to the hospital and back again. And in those situations, we want you to think about whether you want to say at a certain point and we itemize what these points are very specifically, so you're not going to be have the plug pulled before you wanted to. But under these circumstances, when I can't recognize my loved ones, when I can't take care of myself, feed myself, bathe myself, I'm in pain, I am really tired of all these drastic medical things, at what point do you want them all to stop, go into hospice, and now you're looking at a peaceful passage? Again, we really need a document to take care of your wishes on that, and we have one called the living will or the physician's directive.
I will say, I'm sorry, Anita, we do one thing that I usually don't see and that is normally we're going to require a second opinion before these things are put in place or removed. And Anita and I have both known a few clients that the medical profession recommended termination and their spouses or family members declined that, and those people walked out. And so, you know, you can keep me alive for a couple of days, get that second opinion, and make sure enough, this is where we're at.
Yeah, and absolutely. And we also have custom designed some living wills to fit certain religious beliefs. So there's a lot we can do to protect you and to make sure that you're treated the way you want to be treated. Another thing that we offer is a specific document that addresses hand feeding when you're in that situation where basically you're gone, like we often see with the severe dementia, end stage Alzheimer's. People can end up in a lot of difficulty because if they're in a facility, the facility has the legal obligation to continue to feed them by hand. So our healthcare power of attorney will take care of the drastic measures like feeding tubes, but the hand feeding turned out to be a problem because if you're in that situation where you're that absent and you're being cajoled or forced to be fed by hand, you can inhale that food, your swallowing is reduced, and you can end up in a medical emergency from that. So we have a separate document to address that problem.
I just want to plug Anita a minute. You know, she worked with the Catholic Diocese in Fayetteville to come up, or the ethicist, to create a living will for folks of the Catholic faith. She also created a living will for people with Lou Gehrig's disease, which is quite different than a living will that I would have, and other things as well. We have customized these documents to fit people, and we will continue to do that so that each individual client that we have is very unique. And so we're going to customize everything we do for that person, man, woman, family, whatever we need to do to make your plan work.
Thank you, Mitch. It's really, I have to say, one of my most favorite parts of a very wonderful practice is to do that kind of work for people. I really, really love doing it. Now, Tracy, did we have some comments about the college kids?
Yes, we had some responses, and they didn't think it was necessary for their college kids.
Yeah.
None of us want to be caught without that. It's very unpleasant and would be very, our anxiety would be very high.
Yeah. All right. So Mitch mentioned this really briefly a while back when he was talking about his kids. This is a separate two separate documents, actually. One very short and one very comprehensive about business and financial matters. And Mitch, how about you take that one?
Business power of attorney. This deals with all things financial, whether it's real estate, money, 401ks, IRAs, 403bs, any kind of qualified money, annuities, life insurance policies, really about anything you can imagine. We're even going to give somebody the authority to create different kinds of trust for you, whether it's a revocable living trust, particular asset protection trust, or I mean, there's at least 3 different asset protection trusts that we do for people, depending on whether they have veterans benefits or not, or what kind of assets do they have, what's their tax basis, do we need a basis adjustment? And this is some of the complexity we were talking about early. You don't really have to worry about that. We're going to take care of that internally in these documents for you, and it's going to work automatically. And just like a new car, you're going to be able to put your key in there and drive it with no problem. But we want you to have when you take off on your journey, we're going to make sure your toolbox is full. And so one of those tools is a really good financial power of attorney. It's very expansive, and it covers everything that I've seen in 20 plus years, you know, right down to getting a death certificate from the Department of Vital Statistics in well, every state, because we have I had language that I thought addressed that, except the state of Illinois said not specific enough. So we made that very specific. And so every time we run into one of those circumstances, it actually gets longer because we never know what's going to happen in somebody's life. And
Mitch, I have to jump in. I mean, I just finished wrestling with the title company yesterday, and the title company, this was a crazy, well, not so crazy, unfortunately, these days. Our clients were marooned in Costa Rica. They had an offer to sell their house. So the difficulties in doing that internationally were quite extreme. And additionally, the title company insisted that they would not do these documents unless they were original documents. And then I was very proud of myself, and I found the passage in their power of attorney that said, nope, copies are good enough, electronic, Xerox, whatever, they're good. Unfortunately, I have to tell you, it didn't work because of the international character of the transaction. The title company really did need originals. So we worked it out. But at one point, I was very happy that our power of attorney was that comprehensive that it even thought to say about the copies. And ordinarily, that would really do the job. It's just under these special circumstances. I'm telling you, though, the title company was really funny. He said, we've got people in India who can't even get out of their house because of this COVID plague. Otherwise, they'll be attacked on the street. So that's just an example of what our field of work can reveal. It's just there's no telling, but we go really far to protecting you as best as possible.
And we'll think about that and see if we can find an answer for it.
Yeah, unfortunately, yesterday I didn't have time to do it. They had to get the closing done, but there you go. It's always something. All right, so what about this? Maybe you've heard of long-term care insurance. We're back on that subject. That huge expense, you can buy insurance for it, but it's kind of a dilemma if you're healthy and you just don't see that you should have to pay, in addition to everything else you got to pay, for long-term care insurance. You may not need it. Wouldn't it be a waste of money? Let us hear from you on that one. And while you're thinking about that, we'll talk about it. I am so enthused about these products that are out there these days, and our expert agent who can help us find the right policy for our clients. There are vehicles now called hybrid long-term care and life insurance policies. And the way these work is, say you buy a $100,000 payout for your whole life. After you pass, you want your children to get $100,000, and then you pay premiums, and then that's the way that works. But the hybrid part is that if you turn out to need long-term care before you pass, that policy will cover the long-term care costs. So let's say you needed an expenditure of almost a year in a nursing home for $50,000, and then you passed, your heirs would get $50,000 of that. So they're very flexible vehicles and very worthwhile because they give you that extra option so you don't end up paying for something that you would never use. Now, and so provided you can meet the health requirements for that one, and sometimes you do need to produce a chunk of money up front, we have advisors who are very happy to meet with our clients at no cost to them so that they can take over this incredibly complicated landscape of all the insurance policies that are available out there and can find the right one for you. So that's another piece of the estate planning picture that we also want to see our clients get to. Mitch, anything more to say about that one?
Yeah, it's the only life insurance policy I know of that you will always get something out of. And so it's a great, for certain people, if it fits, it is a really, really super good option. Really good.
Yeah. So I hope you aren't asking this question after all that we've shown you, given all of these complexities and all these different options depending on the circumstances. But we do see people really drawn to those legal platforms online that claim to be able to produce an estate plan for you, either do it yourself or at minimal cost. We never want to see our clients do that, because that's what tends to happen. Given all of these possibilities, this is what you're left with when you really wanted to go to Saturn.
Oh, yeah. So I will say this, and I'm sorry to interrupt, but I had a friend, an engineer, really smart guy, went to Rocket Lawyer or something like that, made a trust of his parents and thought it was going to do what he thought it was going to do. And it turned out it crashed and burned. But anyway, I read it for him and I said, well, this is what it says and this is what it does. And he said, really? And I said, yes. He said, man, he said, I spent like 30 hours working on that thing and looking up words and doing all this stuff. And so, yeah, a really intelligent guy did a great job on this trust if the outcome would have been what he wanted it to be, but it actually was not. And he didn't know that. You know, he was an engineer. Sure, he could have built the space shuttle and it would have flew fine, whatever. But, you know, he just didn't know enough about the law to make it happen, even though he had the intellect and he could look up definitions of words. You know, I've been doing this for 20 some years. And I was educated in the area of estate planning and to begin with, and continue to have probably 10 to 20 hours of education every year in that area. And so, you know, he just built the wrong vehicle, but he didn't know it, you know, and as I said, it did crash. And well, we built another one and it works just fine.
That is why it's so important to see us. So this little graphic here, I like this one because this fits a circumstance that I have just encountered also yesterday. What a day yesterday was. Let's see, how can I do this really quickly? Basically, the problem here was that the people involved in a divorce and subsequent marriage had in mind what they wanted to do with an alimony payment. And what they had in mind was not what the documents said at all. So it fell on me explaining what the documents said. They were really outraged because they said, that's not what we had in mind. We wanted it to work this way, and come and see us, please, so that doesn't happen. This is really what we're selling here, is peace of mind. When you come to see us, you will know that we will do everything possible to design you a plan that will fit your circumstances and that will match what you have in mind with what's actually going to happen. So now, do we have questions, Tracy, that we need to answer?
We do. And the first one, I'm going to ask Mitch to answer. And it's about an asset protection trust. What is a bad fit that you mentioned?
Well, if let's say you have $100,000 of an investment account in an investment account, and maybe you have $1,100 or $1,200 in income from let's say Social Security, and you have a home, and you want to put that in an asset protection trust, and it's basically beyond your reach, like with a few exceptions, and you're going to put yourself into a big financial bind. Now, I may say, we'll put your house in that asset protection trust, and we're going to keep your money out because you may need that money to live on, to do something of that nature. Okay, so it's a little easier for me to give you an example of what works in an asset protection trust. Okay, and so I use my family as an example all the time. Big family, a lot of people. And so this was my aunt and my mother had a farm that has been in my family. They would make about the third or fourth generation. I'd be 5. It's a ways from my house where I'm at today. And so we put that farm in an asset protection trust 5 years ago. My mom was 75. My aunt was 68. The 5-year clock is ticked on it. They retained, or at least my aunt retained, something called a life estate, meaning she retains possession and control of that real estate for the rest of her life. She receives the rent from it. There's also some commercial property there. They receive the rent from that. And so nothing in their life changed. They get the income from it, yet we've protected it from Medicaid because it's no longer an available resource because my aunt lives on it. And it's her, every bit of that farm property, which is over 300 acres, is connected to her home. And so under the rules, it's not available. So that was an ideal situation. I can give you another example. I've put, a couple $1 million in an asset protection trust. Well, the client had about $4,000 to $5,000 of income from Social Security, had been a state employee, retired. Maybe she was a teacher and then did the T-drop thing. She got a great income every month. Her income's $4,000 or $5,000 a month. She and her husband had invested very well over the years. And then I put the couple of $1 million in the asset protection trust. Well, she gets, $2,000 or $3,000 a month from that. So just on her income alone and the income out of the asset protection trust, which is going back to her, she will always have enough money to live on, plenty, and she will have enough money to pay for long-term care without worrying about a long-term care policy or anything for that matter. And she still has her home outside the trust. And so there again, nothing in her life changed. So one of the things we're looking for in an asset protection trust is, I don't want to put you in a worse position than you are in today. I want you to be in a better position when we actually implement that plan with an asset protection trust. Some people, we can utilize an asset protection trust with those limited resources that I talk about, and it will work just fine. But it's different for everybody. And yes, there are scenarios where I could take that home. I could take that $100,000. I could put it in a very particular asset protection trust. And just by going down the right road, it'll work, and it'll work great. But some people can't take that road. And so it's very individualized. And so we have to know all the rules. There's so many things that go into planning and getting the outcome we want, but we have a lot of tools to work with. And so usually there's a tool that's going to work for you.
Okay. And another question that we have is, do you recommend a living will or a post, and a post? Could you explain what a post is, and does that work with the living will, or does it take the place of the living will? Anita, could you answer that one?
I'd be happy to. A post stands for Physician's Orders for Life-Sustaining Treatment. And it means exactly what it says. The doctor creates this document, and it's basically intended or mostly used in situations where you are concerned about responding to the emergency medical responders coming to your door. If you have the doctor's orders written out saying, do not resuscitate, do not use that cardiopulmonary resuscitation technique that is pretty brutal and can hurt pretty badly and have some complications. It's one thing for you to have a document that says, I don't want that. It's quite another to have the recognized state form, POLST form, with the doctors having ordered it. So that's what the post is for. It's kind of a last emergency stopgap so that you don't get immediate radical treatment when you don't want it. The living will is a more thoughtful document. It's longer, it has text in it, it has a lot more detail about the various conditions, and it tends to be really important when you're in a facility and you really want the treatment that you've been getting to stop. That's where the living will comes in. So you need both. You need a living will at first, and then when things start to look like they're advancing down the road, then get the post in case the EMT people come. You'll have that document. They work together, but in different circumstances.
So we had another question about why are powers of attorney important in estate plans?
Oh, that's me. Okay, sorry. Here's why, and I get kind of passionate about things, but power of attorney documents are really the cornerstone of planning. You know, as I told you before, with a really good, general durable power of attorney, we're going to give your wife, your children, whoever your trusted agent is, the ability to carry out whatever plan you've got, okay? If we need to create a certain kind of asset protection trust to protect assets, if we need to, whatever we need to do, you're going to give them the power to do it. And we're going to know how to do it. And so that's one of the reasons it's so vitally important. I call them $5,000 power of attorneys. That's because we have to go to court and fix them, and that's what it costs to fix it. And then we don't ever really get to fix it because we're stuck with the probate rules, okay? Probate or our guardianship is basically living probate. Again, we publish our biography for all our neighbors and friends and the public to see in the court records, and we have to ask the judge's permission. And the law constrains the judge. They can only do certain things. And so your guardian is also constrained by those rules. And so those rules very seldom do they let them do what we really need to. The rules have not caught up to where we are today. The rules are very old and they're very stiff and they're very difficult to work with. I have a situation now. This lady is in Arkansas. Her home's in New York. She never signed a power of attorney. So we have a guardianship going in Arkansas for her person and estate because she has money. Well, we have to actually create another guardianship in the state of New York to get this house sold. Okay, so 2 guardianships. Okay, so no power of attorney in this case is probably going to cost in excess of $10,000, $12,000 in attorney's fees. We need these, especially financial documents, and healthcare documents are very important, but we need our financial documents that'll cross borders. They'll go anywhere in the country that we go. They allow our agent to step into our shoes and just be our alter ego, do whatever we can do. And we want them to be really powerful. If we, and I tell people this, do you know your agent can steal you blind and they can take all your money? And then when I get that deer in the headlights look, I know there's a lack of trust, and I start delving into that. So yes, I want those power of attorneys to be extremely powerful, but I also want the right person in that chair. I hope that answered the question.
Okay, we have one other question, and it is, what happens if I have an asset protection trust and I'm caught in that 5-year look back period?
Okay, there is an answer for that. And in the planning process, we're going to plan on that happening, okay? And so we're going to have a plan in the event you are caught in the period, and we will have that worked out in advance. Sometimes that question keeps us from creating an asset protection trust because it's not going to work out good. And so that may be one of the reasons why we don't utilize one for someone, is we can't financially do it without putting you in grave jeopardy. And so we don't. But if you're early enough in life, it'll work. But we have other tools as well. These are the biggest tools we have. But I have somebody building a house. It's amazing what they carry in the back of their truck. Are actually adding on to my house, and they can craft so many things with the tools they have. One, they're a very skilled craftsman to begin with, and they're able to think it through and say, okay, well, I don't have this, and I don't have this, and I don't have this, but I do have this, and I know I can do this with it. It may take me a little longer, but I'll get that job done. And so, we have a whole lot of tools. Sometimes we even build special tools to get the job done from a legal perspective. But, there's just lots of things to do. And, it seems like we do have 4 or 5 main tools that we use a lot, but we do actually build some custom tools, and we may never use them again. And so it just depends on you. What do you need? We'll take care of that for you.
And those are all of the questions that I received.
Well, thank you, Tracy, for fielding them. Thank you, everybody, for your attention and asking the questions that are so interesting for us to hear and answer. Please take down our contact information from the panel that you're looking at. And we look forward to hearing from you if you are so inclined. Anything else, anybody?
Yes. does anybody, I have a halo today because I'm such a good lawyer, and I can show it to anybody if they want to see it. Does anybody want to see my halo? Just say yes.
I'm
Yeah.
afraid to hear
Okay,
it.
give me just a minute. We'll see if it works. There it is. I thought I would do this presentation under this light, but it doesn't work real good. But I do have a halo. Do you not see it right up here?
Yes.
we
Okay.
see it.
I thought it looked like a halo, and I thought I'll look like a really good lawyer, or a really angelic lawyer. So anyway, my stab at humor for the day. So, and as you can see, I'm sitting in my basement. I should have left the light off, but it was the only quiet place I had. So anyway, thank you all very, very much. And we look forward to hearing from you in the future, and certainly wish you the very best, and hope you're very careful and go out and enjoy the sunshine this afternoon.
And thank you, Fayetteville Public Library. Such a great institution. We're hanging with you in this pandemic, and we really appreciate you, Susie. Thank you.
Yes,
Bye, everybody.
Bye-bye.
Bye.